Hi, my name is Meghan Matt. I am a law student, an advocate, and a mother of 4 kids. Thank you for giving me a few minutes to speak today. As I begin, I'd like you to recall that regarding the discussion of an earlier bill in this room, it was a gentleman on this side, I'm not sure who it was, pointed out that if a school nurse accidentally infected a child with hepatitis, the family would have no recourse in a civil suit due to the immunity protections. When listening to the following information and stories, please consider whether these families should also be granted legal recourse. 1 in 3 people killed by a stranger in America is killed by a police officer. More than 1,000 people are killed by police every year in America. The country with the next highest number is Canada. Their yearly average is 36. Nearly 60% of American victims of police violence did not have a gun, and they were not involved in activities that should have ever required police intervention at all, such as mental health crises. The Wisconsin Innocence Project conducted a study and found that police misconduct was a factor in as many as 50% of all wrongful convictions involving DNA evidence. In the last 7 years, police in Louisiana have killed 148 people. 80 of them were black. We rank 14th in the nation for the highest rate of police killings. 99% of killings by police do not result in officers being charged. But also under qualified immunity, victims lose their ability to obtain judgment when their constitutional rights have been violated. As Mr. Craig and Representative Jordan and so many people have said, the clearly established law is a nearly impossible standard for victims of police violence to meet. From a practical standpoint, how does one ever establish precedent if another identical case is always required? The cycle stays on repeat. During my legal clerkships, and in researching and writing my law review article on the Fourth Amendment, I've come across countless cases of police brutality. If you haven't recently, pull up a search in Lexis or Westlaw for incidences of police violence. Have your aides run a search. Try to have them print them out. There isn't enough paper in this Capitol building to cover the amount of cases that you will find. In a huge portion of these, the clearly established factor is the prominent reason for denying justice to victims. On a spring evening in 2013, Kari Illich was wandering down a quiet, tree-lined suburban road, naked and covered in scratches. When police arrived in response to a trespassing call, they shocked him 6 times with a stun gun before he fell to the ground. As he lay face down on the ground, one deputy shocked him 13 more times. Then they hogtied him, shackling his ankles with leg irons and fastening them to his handcuffs. Then a 385-pound officer kneeled on his upper back until he went limp. He died of cardiac arrest and was pronounced dead on arrival at the hospital. The case traveled through the courts, with the appellate court ultimately finding no precedent clearly establishing that the officer's treatment of Kari was unlawful. The family appealed to the Supreme Court, but the writ was denied. In 2014, Alexander Baxter was sitting on a curb, surrounded by police with his hands in the air, when officers released dogs on him and he was viciously attacked and bitten. When Baxter sued, the appellate court tossed out his case. They held that while it was established that a police dog couldn't be unleashed on a suspect lying down, there was no case to address someone sitting down with their hands up. On Monday, the Supreme Court declined to hear his case as well. We have perpetuated a cycle of abuse and death under the guise of law. How many other practices can we look back on that were once legal that we now realize were wrong? This is a bipartisan issue. As mentioned previously, Justice Thomas has called for an end to qualified immunity. He pointed out that the right to sue applies categorically to the deprivation of constitutional rights under the color of state law. I like to think that when Justice Thomas and Justice Sotomayor agree, and when the ACLU and the Cato Institute agree, we should all be paying attention. As a parent, it's my job to teach my kids right from wrong. Most of the time, they are exceptional kids, the very best, in my opinion. But if they hit their sibling or they get out of line, they also understand there are consequences. When we go out in public and they act up, I am embarrassed because it reflects poorly on my parenting. Perhaps you believe the police are exceptional people, the very best in your opinion. So why is it when they clearly step out of line, there are no consequences? Isn't this embarrassing to the institution as a whole? This bill does not affect officers who act reasonably and ethically. And I know that lawyers love loopholes, but this loophole is a stain on good police, and frankly on our Constitution. If the institution of policing is as full of honesty and integrity as we believe it to be, then this bill will only further prove that. To quote a local poet, activist, and friend, Donnie Rose, police lawlessness is protected by the legislative branch and dismissed by the judicial branch. As the folks in power, you have the ability to stand up for the powerless. I implore you to do so, because justice delayed is justice denied. Thank you.